Alrighty, I think we're going to go ahead and start. Good evening, everyone. Welcome to our event, The Executive in 2020. My name is Chloe Knox, and I'm the Vice President for Speakers for UVA's Federalist Society chapter. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Tonight's event will be moderated by UVA law graduate Jack Lund. Jack is a double who, and after graduating in 2016, clerked on the Fifth Circuit. He is now an associate in the DC office of Covington and Burling. Jack, thanks so much for being here tonight. I really appreciate it. I'm going to go ahead and turn the floor over to you.
Great, thanks, Chloe. As a proud double who, I'm very happy to be moderating today's event. I'll briefly introduce today's panelists, each of whom has a recent book on presidential power. After that, the panelists will lay out their competing views. I'll then ask the first question and moderate a Q&A. Please submit your questions through the Q&A function on the bottom of your screen as they occur to you. I'll try to get through as many of them as we can. Our first panelist is UVA's own Professor Sai Prakash. He is a graduate of Yale Law School and former clerk to Justice Clarence Thomas. His newest book, titled The Living Presidency, an originalist argument against its ever-expanding powers, was released earlier this year. Our second panelist is Professor John Yoo from the UC Berkeley School of Law. He is also a graduate of Yale Law School and is also a former Thomas clerk. His newest book is called Defender-in-Chief, Donald Trump's Fight for Presidential Power. Gentlemen, have at it.
So Jack, John's going to go first, then I'll go second.
Works for me.
Thank you, everybody. It's great to be here. Thanks to the Federal Society chapter, UVA, for inviting me. I can't think of anything better than to spend an evening with UVA students without actually having to be in Charlottesville. It's perfect. I get to stay in California and I get to be with all of you. How can mess with success? It's also great to be here in a debate with my friend, Sai Prakash. You may know we both clerked for Justice Clarence Thomas the same year, which means because of the housing shortage in Washington, we had to share an office for a whole year together, which was a terrible experience. But I can't imagine what it's like for all of you there who have to spend 3 years cooped up with him in one building. I really feel for you guys. But I expect you will see that I'm going to treat him with the lack of deference that he deserves. And I encourage all of you not to be afraid of Sai, but to treat him like, you know what he is, the California surfer dude that he really is. I mean, he's in Charlottesville, but he is actually grew up in San Diego. He's a beach bum kid from out here. Can you imagine how he got stuck in the middle of horse country in Virginia? I feel so bad for him. So I really look forward to this, and I look forward to all your questions and comments. So I wrote this book, Defender-in-Chief. Buy one now. Buy many of them. It actually looks better when you have 3 or 4 of them in a big pile like I do in my office. And then you could buy one of Sai's. You could make it like a little jigsaw. Sai, me, Sai, me. So I started writing this book 4 years ago. 4 years ago, I was a lot more worried about Trump and the Constitution than I am now. Trump campaigned as a populist, and populists always strain against the restraints on their power. Populists think they have a mandate from the nation to shake things up, to overthrow the status quo, to change the way we do business in Washington. And often the Constitution represents the status quo, represents the ways of the past. But a funny thing happened on the way to 2020. Trump certainly was politically disruptive, changed the way that presidents relate with the people, with the press, with other institutions. He broke all kinds of political norms left and right. But in doing that, he drove his opponents so crazy that they are the ones who are now contemplating serious, revolutionary in some respects, constitutional change, leaving to Trump, I think, the field of defending the traditional presidency, the one rooted in the text and structure and the practice of his predecessors. So let me give you some examples of this dynamic at work. The most obvious one is the one we're watching right now. I'm so glad so many of you interrupted your day-to-day coverage of the Amy Coney Barrett hearings to take a step back and think about the presidency. Look at what's happened here. A vacancy arises on the Supreme Court. President, as is his constitutional right, nominates someone for that vacancy. Every president who's had a vacancy in the last year of his presidential term has nominated someone. Doesn't mean they'll get confirmed, but they have all nominated them, including President Obama 4 years ago. It's really the Senate that has the question before it about whether to confirm somebody to that seat in the last year of a presidency or to wait for the election and let the election decide who's going to get to fill this seat. In all the in all the vacancies of the last year of a president where the president and the Senate were of the same party, all of them were confirmed except for the very last one, which was Abe Fortas, who was nominated by LBJ to be Chief Justice and suffered some very serious allegations of personal corruption and triggered a bipartisan filibuster against his confirmation. It's only in years when the president and the Senate are controlled by separate parties that people haven't been confirmed. If you were to take the rule that some opponents of Barrett are pushing right now, that no vacancy should be filled in the last year of a presidential administration, no matter what, no matter the alignment of the president and the Senate, then we would have lost some of our greatest justices. Chief Justice John Marshall, the greatest justice in American history. He was both nominated and confirmed after Thomas Jefferson had won the election of 1800. Louis Brandeis, Benjamin Cardozo, two more of our greatest justices in history, were also last year appointments. So Trump, undertakes a sort of regular exercise of presidential power. What's the response? We're going to pack the court. Now, as you all know, I'm sure, the power to set the size of the Supreme Court clearly rests in Congress. On the other hand, we have had a constitutional norm since 1869 of having 9 justices, and going well before that, the idea of not meddling with the size of the Supreme Court until we get the kind of answers we want out of it. Couldn't think of something like that would threaten the rule of law more so in our country. And this is such a bad idea that even FDR in 1937, at the head of a stunning re-election where his party controlled 2/3 of the House and the Senate, he even failed in a blatant effort to pack the court, much along the lines that you're hearing today, from 9 to 15 justices. This is just the latest example, I think, of how Trump, in actually exercising his regular constitutional powers, but because of his political demeanor, has driven his opponents so crazy. They're the ones who are really contemplating serious assaults on the Constitution. It's Trump's opponents, for example, who are proposing now to be rid of the Electoral College, the way that we have picked presidents for 230 years. It's Trump's opponents who want to make permanent independent councils, which seize away from the president the power to enforce the laws, who turn our political and policy disputes into matters for criminal law. It's not Trump, it's his opponents who claim that the federal government, in defending federal buildings and personnel in our cities this summer, were sending an occupying army that was on the verge of fascism. Those are not the rantings of some wild bloggers. Those are the words printed on the New York Times editorial page this summer. It's not Trump, his opponents who contemplate a vast expansion of the powers of the federal government, who are calling for, see, Sai already plunged into darkness. He has no idea what's going on. This is how he writes his best work, with the lights off. So there he is. All right. So you're on mute, which is,
I think they
is
can only
perfect.
see you, John, when you're talking.
So yeah, that's right. But I'm in California. We don't have any electricity here. We only work on natural light. When the sun goes down, we have to actually go back to our caves. We can't do any work here. So I was just with the Green New Deal, contemplating a vast expansion of the powers of the federal government, I think well beyond the scope anticipated by the founders. Meanwhile, that means that Trump has been the one depending on sort of regular, I think, traditional interpretations of the Constitution, and in fact has been doing it mostly as a shield to defend himself from attacks on the legitimacy of his election. take two of the big crises of his presidency. The first one, the Russia collusion investigation. You would have thought that Donald Trump had committed some terrible constitutional sin by firing Jim Comey, the head of the FBI, and then continuing to fight with Robert Mueller, the special counsel who was appointed to investigate him. But in fact, I think President Trump was trying to restore the founding 18th century Constitution. That Constitution gives only the president the responsibility to take care that the laws are faithfully executed and that everybody who works in the executive branch performing that task are his assistants and have to be removable for any reason at all, because the president has to make sure that they are following his interpretation of federal law and his agenda for law enforcement. Instead, what defenders of Comey and Mueller were defending was something that you could call the progressive 20th century Constitution, the constitutional changes that were devised by Woodrow Wilson, the idea that public policy questions were too important for politics, that instead these are questions of science, technical expertise, and professional judgment, and that we should insulate those people who make those decisions as far away from politics as possible. And you could see, I think, Trump's effort to take control again over law enforcement as a fight between the original 18th century Constitution that we have and then this 20th century, I think, tumor that has grown onto that Constitution, which I think is best expressed now in the administrative state. The second great crisis, constitutional crisis of Trump's presidency, also involved this battle. That was, of course, impeachment. Again, you had this bureaucracy that thought that its judgment and technical expertise should be superior to politics. Right? You had the Foreign Service and the National Security and Foreign Policy bureaucracy that thought that the interagency process, as it was called, should dictate the foreign policy of the United States. But instead, under the 18th century Constitution, the president is vested with the executive power, and it's been commonly understood, it was commonly understood at that time that the executive power included the power to conduct foreign relations. And you could see Trump, however unorthodox his goals, however unorthodox his means, was trying to reassert that constitutional principle. Now, I think Sai and I, our bigger disputes are going to be in foreign relations. I, for example, think that Trump, in dropping giant bombs in Afghanistan, ordering the killing of General Soleimani, the Iranian general in Iraq, has been properly using his constitutional authority to start and conduct hostilities subject to Congress's control over funding and the size and shape of the military. But those who think that Congress's declare war clause power means that Congress only can decide whether to start wars, I think are struck by a puzzle by the Trump administration, because even though Trump has been making broad claims about his commander-in-chief power, he has been using that power to actually withdraw the United States, to lower our involvement in foreign conflicts. He has pulled us out of Syria. He's drawn down troops in Iraq. He's trying to pull completely out of Afghanistan. He's threatened to redeploy troops out of Germany and Japan and South Korea, where they've all been for about 70 years. If Congress really had this kind of power to set the policy of war and the president was just the agent to carry it out, which is the approach we have to statutes, by the way, then how could Trump do this? Why is it up to Congress, which Congress, by the way, tends to be more warlike now than the executive branch? Why is it up to Congress to decide where the troops are and how long they stay and how long they fight? The fact that Trump can draw down those troops just as well as send them there in the first place shows that's really the president's commander-in-chief power all along that has the role of the initiative, and that Congress plays a secondary role in war and foreign policy. So let me just close by saying, some people say in response to criticism of my book, how could it be that Trump, who doesn't really know much about the Constitution, who got all kinds of questions wrong during the debates about the Constitution, how could he be defending the Constitution? Let me close by saying this was the founders' design. Right? They didn't expect the people in office to be angels. Right? Madison says, if if we were all angels, we would have no need for government and we would have no need for a constitution. Instead, they expected people once in office to pursue their ambitions and to pursue the ambitions of their branch. They didn't have to think about the Constitution as a whole. What they thought would happen, Madison makes this very clear in the Federalist Papers, is that the branches would fight against each other. Ambition, he said, would counteract ambition. And that constant jousting, that constant fighting is what would keep the federal government within its bounds and would create the space for individual liberty and private civil society. So it doesn't matter whether Trump is thinking about the Constitution or not. What matters is that Trump pursues his own self-interest and that of the executive branch and fighting with Congress. And by doing that, he unexpectedly, maybe even unintentionally, becomes a greater defender of the Constitution. So thank you very much for being with me. I look forward to hearing from Sai and all of you.
Go ahead.
All right, it's great to be with you guys. I haven't met all of you, but I certainly hope to do so. And I hope one day we're actually able to meet in person and not doing these Zoom calls. John's right, I'm from California, totally and utterly from California, radically from California. But I love Charlottesville. I love the mountains, and I also love the Costco and the Trader Joe's. So it's great to be with you today. Now, maybe you'll see John's book at Costco, soon. John's book, Defender in Chief, but it's also available on Amazon. John's right. This is a terrific stocking stuffer, and you have many stockings to stuff. But I'd be remiss if I didn't mention the Living Presidency as well. Also available at Amazon, maybe not at Costco. You should, make sure you get a copy of this. I want to see each one of you with 4 things in your hands: the Constitution, the Federalist Papers, John's book, and my book at all times, right? Just walk around with it. I had a professor who used to keep the Constitution in his pocket, and he'd say, "This gives me the right." And now you'll know all about the presidency and be able to do the same sort of thing. And as John said, it's a delight to be debating John. John and I had great fun clerking for Justice Thomas. What a year that we had. The justice liked to say that John had a crystal ball and he could use that to get in touch with the framers and divine exactly what they meant. And I think John really believed this and ultimately got a crystal ball. I'll say one other thing. You're going to be taking con law in the fall. John and I wrote this article several years ago called The Origins of Judicial Review. It's all about why judicial review is an implied feature of our Constitution. It's all about why Marbury didn't make it up. And so you might want to take a look at that to see where we've agreed in the past. So my book is not focused on Donald Trump at all. It's not really about Donald Trump. It's about where the presidency is today. And to get a sense of where the presidency is today, the book begins by taking you back to the founding and describes the original presidency. And that actually is part of my first book called the Imperial from the Beginning, the Constitution of the Original Executive. And that book's all about the founding presidency and all its myriad aspects. It's a soup to nuts book on everything you wanted to know about the original presidency, more than you cared to know about the original presidency. And the basic thesis is the presidency was far more powerful than any state or federal executive at the time. It was designed to be more powerful. They gave the president a veto. Not true at the state level for the most part. They gave the president lion's share in appointments, not true at the state level. They gave the president a sweeping pardon power, not true at the state level. They gave the president authority over treaties with the advice and consent of the Senate, obviously not true at the state level. And they gave the president the vesting power, the executive power, the vesting clause, which granted the president generic executive powers of the sort that weren't specified in the Constitution, which would have included authority over law execution. Law execution is what makes the president an executive, but also ability to control executive officers, be they diplomats and be they civil servants, right? Be they civil officers of various sorts. And so the president could tell them what to do when they executed laws. He could tell ambassadors what to say to foreign countries. He could fire them, right, if he didn't like what they were doing. And this is all part of the grant of executive power. So that's a sketch of the powers. What about the constraints? Well, I'll mention 3 today because they're relevant to the story later. First, the president could not declare war, meaning he could not wage war without congressional authorization. So John and I differ on this. I think every president from the good old days of the 18th and early 19th century denied that they could take the nation to war, including Washington, Adams, Jefferson, Madison, Monroe, and on and on and on, because they understood that the power to declare war was the power to decide to wage it. And in fact, most 18th century wars were declared through the mouths of cannons. They were the nation states declared war just by waging it. They didn't need to issue a piece of paper. In our system, it's different because Congress is the only branch that can declare war, and Congress acts by bicamerals and presentment. So the president could recommend war, and the president could veto a war declaration, but what he couldn't do is take the nation to war, because in doing so, he would be declaring war, and the Constitution implicitly gives that to Congress alone, and it's not something shared with the presidency. Another limit is the treaty clause. The president can't make significant international agreements without the Senate's 2/3 consent. He can make more minor agreements, so-called sole executive agreements, but he can't make treaties without the 2/3 of the Senate's consent. And that's in part a federalism constraint designed to ensure that the treaty power doesn't infringe the rights of the states. And so there's a super high threshold. They were worried that the US might make treaties that would give away navigation rights in the Mississippi, and they made it very difficult to make a treaty. And then finally, the president had to take care that the laws are faithfully executed. He could recommend measures, he could veto measures, but he couldn't write laws on his own, right? And he had to faithfully execute the laws, meaning he had to faithfully interpret them and not misinterpret them. And so he was basically a servant of the laws, albeit with an influence on the shape that laws would take that could be exercised in the front end. If we flash forward today, I think these three elements no longer are part of our lived Constitution, the Constitution we actually experience on a day-to-day basis. Everyone is fully aware that presidents start wars today by just basically taking the nation to war. Think of the Korean War, think more recently of the Libyan conflict, the Libyan War, where Barack Obama bombed Libya for months on end and pointedly tried to kill Muammar Gaddafi, engage in regime change. And that's in part because modern presidents are able to say, look at the actions of my predecessors. They've put a gloss on the executive power, citing an opinion of Felix Frankfurter from the Youngstown case. What about treaties? We don't make many treaties anymore, or more precisely, we don't make treaties consistent with Article 2. Instead, we make treaties on the international plane, but Congress approves of them by simple majority in both chambers, or the president uses his sole executive agreement power. And so this significant check on making significant international agreements is gone, because the president now just seeks a simple majority in both chambers, or does make treaties on his own constitutional authority in a manner that would have been. Once again, it's simple accretion of practices. That is to say, some president looked at prior practices, misconstrued them, argued that they could bypass the Senate by using this congressional executive agreement construct, and then started making treaties. NAFTA is one such treaty. NAFTA is a treaty on the international plane, but it wasn't consented to by 2/3 of the Senate, because Bill Clinton could not get 2/3 of the Senate to consent to that. Instead, he just sought a majority vote in both chambers. And after he got it, he signed the treaty. He ratified the treaty. So that's a bypassing of the treaty clause. If you favor more international agreements, you won't mourn for its passage. But if you favor following the Constitution, you have to mourn, right? The treaty clause is basically a shadow of its former self. It really has no teeth to it anymore. Presidents don't really. If you don't want a treaty ratified, you'd submit it to the Senate as a treaty, right? If you want it ratified, you would just go to the Congress and try to get a congressional executive agreement. And then finally, law execution. I think presidents less and less conceive of themselves as law executors. Most Americans don't think that presidents are the chief law enforcement officer. If they think about it at all, I think it's the attorney general. But that's the principal function of an executive. That's where the executive gets its name. Today, we live in an era of executive law, right? Congress delegates legislative power to the president, basically delegating vast arrays of legislative power. There are things like the Chevron doctrine, where the courts misconstrue statutes and argue that the Congress has delegated legislative power, interstitial legislative power to the executive. And then on top of all that, because presidents run on a policy platform and want to get reelected, they make promises about policy that they can't always keep because they can't get them through Congress. And then they are tempted to adopt a pen and phone strategy of the sort that Barack Obama adopted in the middle of his presidency. When he was thwarted by Congress, what did he do? He rewrote statutes. That is to say, he misinterpreted statutes to expand his authority and in other cases to contract restrictions on his authority. This is not a feature of Barack Obama, it's a feature of the modern presidency. I can go back to George W. Bush and his auto bailout. Congress passed a law bailing out the financial institutions of our nation. They did not allow the bailout of manufacturing companies. Manufacturing companies are not financial institutions. The House passed an auto bailout bill, the Senate would not. But George W. Bush used the financial institution bailout to bail out the auto companies, and he just said it had to be done. Maybe it had to be done, but it wasn't legal, right? Because you can't read a statute that covers financial institutions to cover auto companies, because if you can, it covers everybody, right? There's nothing about GM and Chrysler that render them financial institutions. He basically read out the word financial. It's just institutions, right? You could bail out institutions, and that's what he did. And Barack Obama continued the program because he didn't want there to be, they both didn't want massive unemployment. That's a salutary goal, but there's no money to do that, right? You don't get to rewrite the statutes because you don't want massive unemployment. Now, there wasn't a hue and outcry about this, except from libertarians, because most people don't want the automobile companies to go out of business. But if you believe in an executive under the law, you have to lament the fact that this happened. And I've already mentioned the Obama administration. Let me mention a couple of examples. The Obamacare Act, the ACA, authorized insurance company subsidies, but did not provide an appropriation. The Obama administration understood this, went to Congress and asked for an appropriation. Congress said, hell no, we're not going to cooperate in implementing your act. And then the Obama administration did a 180 and said, oh, you know what? Don't worry about that request. We read the statute as not only authorizing the expenditure of funds, but appropriating it as well, which is just a ridiculous reading of the statute. And they themselves had not read the statute that way until they had to, right? It was necessity was the mother of that argument. And they invented an argument and ran with it. And they subsidized these insurance companies for years until President Trump came into office. And the final thing I'll mention is President Trump's wall. I happen to favor a wall, a beautiful wall with a beautiful door, at least on some parts of the border. Donald Trump could not get a wall through the Republican Congress. He actually got funding for his wall in 2019, courtesy of Nancy Pelosi. They gave him $1.5 billion. The same day he got it, he declared a national emergency and transferred funds from Defense Department accounts to his wall. Now, he wasn't the first president to declare a phony national emergency. There are actually dozens of current national emergencies that are declared by presidents repeatedly year after year. And they're basically relying upon what you might call a glossy understanding of emergency, right? Presidents basically read those statutes to say the following: whenever the president finds it useful or convenient, he can access these funds or access the discretion contained within these statutes. And that's to take the words or the phrase national emergency out of them and add the words useful or convenient. Now, again, I may favor the wall, you may favor the wall, you may oppose the wall, but it's not right to read a statute that says national emergency if it's just at the whim of the president. There are statutes that do say whenever the president finds it's useful or convenient to do something, he can access some statutory authority. They don't require an actual national emergency or even an honest opinion that there is a national emergency. These do. There's no reason to include the words national emergency if what you mean by that it's at the whim of the president. And so there is a sense in which it's legal. If all that you're going to say is it's been done before and therefore it's legal, then it's legal. But most of the time, conservatives don't have this sort of dynamic approach to statutory interpretation. They ask, what did the phrase mean at the time of enactment? Not what did presidents pervert the statute to mean so that successors can rely upon that meaning. So even though the book isn't about the wall and I don't talk about Trump, I don't think that this administration has been materially different. than its predecessors. I then pivot to why this has happened, and I'll mention a couple of things before ending my comments, because I want you to be tantalized and be like, what did he say in that book? I really need to, inquiring minds want to know, and I need to know more about this. So I mentioned earlier that presidents now make legislative promises, and I'd add that we expect greatness of our presidents. We expect them to solve all our problems, and we expect them to keep all their legislative promises. This creates pressure on presidents to circumvent Congress when Congress does not oblige them, right? They're more apt to want to change things administratively through the pen and phone and eraser strategy. And they're more apt to just misconstrue statutes and, if need be, misconstrue the Constitution. So this is an extra constitutional development that has had, I think, bad consequences for a sensible originalist approach to constitutional interpretation and statutory interpretation. I'll mention two others: the rise of presidents and the rise of presidents as party chieftains and the rise of political parties has basically enervated Congress. Congress no longer can stand up to the president because half of Congress is beholden to the president, views the president as party chieftain, and is generally unwilling to criticize the president, especially when the president advances the party's agenda. There were no Democrats who criticized Barack Obama for Daca and Daca, and there were very few Republicans that criticized the president for the wall, and they were probably Republicans who really didn't favor the wall. But what this means is that Congress is basically divided, from the get-go in any interbranch dispute in a way that's not true for the executive branch. And a divided Congress is, an institution that will fall, to paraphrase or to borrow from Abraham Lincoln. And then the final thing I'll mention is the idea of a living constitution. John mentioned the progressive constitution. And one of the features of Woodrow Wilson's theory is that we shouldn't be bound to ancient conceptions of the presidency. And I think that understanding of the presidency has been accepted certainly by the executive branch and sometimes by the law professoriate. And it turns out, if you believe in a living constitution with respect to Congress, i.e. a living commerce clause, a commerce clause that isn't tied to a horse and buggy conception of commerce, as Franklin Roosevelt said, and if you believe in a living conception of rights, where the content of constitutional rights evolves over time, oftentimes in a progressive way, then why would the presidency be immune from these tendencies and these theories? It's not, right? If you're going to excuse an evolving commerce clause, and if you're going to celebrate an evolving set of rights, of course you're going to have a living presidency that changes over time. And so progressives need to choose. They either favor a living constitution or they don't. And if they favor it, they can't be systematically opposed to the new developments and mutations in the presidency. So I'll end there. I really look forward to your questions, and I look forward to meeting you all sooner or later. Thanks.
Professor Yu, do you want to offer a short reply, or should we move straight away to questions?
Just quickly on the war powers question, because I think that's the biggest debate we have. So Sai, pulled out his pocket constitution. So unfortunately, mine has got so many other provisions. It's this big. It doesn't actually fit in my pocket. But that's because Sai's got all different versions of the Constitution he's working on there. So let's use the one that's the official US government version. So all of you first years out there, I hope you have your pocket Constitution with you. So turn with me to Article 1, Section 10. So one of the things you're seeing in the confirmation hearing for Amy Coney Barrett right now, I think, are this question: how do we read constitutional texts? Especially one of the rules, I think, is that every word in the Constitution should have meaning, and that if there are differences in wording, that you give them different meanings. So a lot of people who take Sai's view on the war power question think the power to declare war really meant the power to start wars. And that, notice there's no exception for self-defense. So usually they have to say, and there's an implicit exception that you don't need to declare war if you're attacked. So let's look at Article 1, Section 10, right? So, and I think actually for all of you who are first years, there's a lot you can learn just by looking at the text of the Constitution, free from all the illusions and deceptions that we're going to teach you in law school over the next 3 years. There's a lot of things that you might notice that have escaped notice before. I was reading this for the first time when I started as a law professor, and I think I'm the first one who ever noticed this provision. So it says, I think this is really interesting, no state shall, without the consent of Congress, engage in war, right? They don't say declare war, they say engage in war. And then they even have the exception. The text says, unless actually invaded or in such imminent danger as will not admit of delay. So they even included a written exception for self-defense and quite expanded, not just actual attack, but the anticipation of an attack, which people say has to be there in the declare war clause, but it's not there, so we'll just pretend it's there. So what I say to people who take Sai's side is, the framers could have just said, the president shall not, without the consent of Congress, and use the exact same words if they wanted to be clear as they think the Constitution is with the declare war clause. Why would they use this provision here and then use declare war somewhere else to mean exactly the same thing? Doesn't make any sense. So that's why I argue the declare war clause actually means something different, which is Congress has the power to set the status under international law of the hostilities, but that doesn't have anything to do with how, as a matter of domestic law, we decide to go to war. And so people say, well, that means the president can wage war whenever they want. That's Sai's argument, without any kind of check. And so the change there is not because of the Constitution, it's because of Congress. Until 1945, we had no standing military. So any president who wanted to wage war would have to go to Congress and say, please build me an army and navy to fight this war. Congress had a perfect and complete check because of the funding power and its power to raise the military. After 1945, what does Congress do? It creates an enormous military, one that's designed to conduct offensive operations abroad in other people's countries. Congress doesn't have to do that. Congress could have kept the military small. It could have designed a different kind of military. Aircraft carriers are not good at continental defense. You need to build all these aircraft carrier groups, which are designed to put airports next to other people's countries to make it easy to bomb them. Right? It's because Congress wanted to make it easier for presidents to conduct war abroad. They didn't want to take any responsibility by having to get involved when deciding whether to, as the Constitution says, engage in war. And so it's kind of like the administrative state. They said, you, the executive branch, you get all those resources. You can go to war if you want. We don't want any responsibility or accountability for it. And I think that's what I mean when I say President Trump has followed the practice of his predecessors who have made this argument. But I think it's rooted in the constitutional text and structure as well.
Yeah, I think we should probably move over to questions. Thank you both for your thoughtful presentations. I'm going to exercise the moderator's prerogative and ask the first question. For everyone out there listening, please get your questions into the Q&A box at the bottom of the screen. We'll try to get through as many as we can. So I'm sure everyone listening knows the story of George Washington riding at the head of a federalized militia to suppress the Whiskey Rebellion. I'm also sure that we're all aware that armed groups of Americans have recently taken to the streets. In the well-publicized case of the Capitol Hill Autonomous Zone, or CHAZ, such a group declared its own independence. Assuming that President Trump is capable of mounting a horse, would he have been permitted to ride into CHAZ at the head of an armed force? Would it matter if the governor of Washington state objected?
Well, this is a good question. It's one we've all been talking about. And I think one thing to understand, it's again, goes to the dynamic in my book. You would think that President Trump was imposing some kind of authoritarian dictatorship if we were to get on said horse. It would have to be a very big, strong horse, by the way, to carry this guy. I mean, he's a big guy. He's eaten too many McDonald's double cheeseburgers. So, I mean, I feel bad for the horse more than for the other people involved. And you would think he was just exercising some kind of unconstitutional power. And actually, it's very similar, I think, to the arguments Sai made about the wall, other people have made about Trump. When you really look at what he's done, it actually, I think, again, lies within powers delegated by Congress for the most part, traditional arguments made about the presidency, and is not some kind of radical claim of constitutional authority that people assert. So take your example. First, if the governor invites him, then there's something called the Insurrection Act, which makes it clear that Congress says that the president can call out the militia. But another part of the Insurrection Act says that even if there's no state request, the president can use the federal government and the militia if necessary to enforce federal law and to protect federal installations, federal property, federal personnel. And so if Trump limits himself to that, he's actually within the contours of the Insurrection Act and other statutes. Then there is a constitutional question that could be raised about just law enforcement and protecting federal interests that are not part of a statute. So for example, Dwight Eisenhower, I think, made this claim when he called out the 101st Airborne to escort kids to school in the South after Brown versus Board of Education. Abraham Lincoln made a similar claim at the start and throughout the Civil War that the Constitution gave him the power under the Take Care Clause, the Commander-in-Chief Clause, and the executive power to prevent secession from occurring. I don't think we need to reach that question here with Donald Trump marching into Seattle on a horse. But if he were to do so to restore just the complete collapse of law and order in that area, I think he both has statutory and constitutional power.
I agree with what John said. There's statutory authority for doing what you're describing. Most presidents haven't marched on the battlefield, and Washington never made it all the way to Western Pennsylvania. He pulled away at the last second. He certainly could have if he wanted to. And I think the reaction to the president's actions with respect to these riots, I think, really reflects a political reaction to the president rather than a legal one. I think if you listen to lawyers, they're mostly saying that it would be legal to call out the militia to suppress these rioters because they are interfering with the execution of federal law, both by destroying federal property, but also preventing the application of federal law into these autonomous zones. So I agree with much of what John said.
Great. We've got a number of audience questions. Let's get right to it. I think this one's probably directed mostly towards Professor Prakash. Is there any hope for the return of the proper constitutional treaty approval process? I take it that Professor Yu doesn't think that there needs to be a return to a proper constitutional treaty approval process, but maybe you both want to weigh in.
So I'll begin. John actually has an interesting article about this in the Columbia Law Review, and you should take a look at it. I think the problem with the treaty process and the circumvention is, even if 2/3 of the Senate don't want a treaty approved, getting a majority of the Senate to approve gives the president some kind of imprimatur of part of Congress. And of course, when he gets the other imprimatur from the House, it seems like to many people a substitute for Senate approval. So it's very hard to imagine a senator or senators generally pushing back against this tradition. They've tried to push back with respect to arms control. Maybe John can discuss this. They've tried to say, well, arms control treaties are different than other sorts of treaties, and so you can't just get a statute of Congress passed. You need to get the supermajority consent of the Senate. But I think the way to think about this is the Senate is less special than it was in the past, right? The Senate had these two unique functions, and one has basically been bypassed. So I think it's a little harder to see how the Senate's going to reassert itself. I think one way would be for the Senate to just deny that there's a treaty, right? If think of NAFTA, right? The Senate could just refuse to appropriate funds for NAFTA if there was no treaty actually made consistent with the Constitution.
I agree with Sai that the treaty clause might be one of the most unconstitutionally ignored provisions of the Constitution, because it's not an obscure provision. It's one of the most important ones. And yet, I think the figure is we don't make any more than 12 to 20 treaties a year, but we make 12,000 of these different kinds of agreements that have not been through the treaty clause. On the other hand, it's interesting. The treaty clause still seems to be used for important agreements. So security alliances like NATO, still done by the treaty clause. As Sai mentioned, arms control agreements, also done through the treaty clause. I can't think of an important arms control agreement that was done as a congressional executive agreement. The main important agreements that are not done through the treaty power are trade agreements. So like NAFTA, the USCMA now, I can't remember, it's USMC, I can't remember who got, USMCA, I think it's called. The WTO agreement and so on, those are all done as statutes. And so it's a positive. I don't think this is an issue about the presidency per se. It's more an issue, I think, with the Senate. The Senate has sort of acceded to this. It could easily have stopped all of them if it wanted to by saying we're standing up for our prerogatives under the treaty clause. The thing that I think is interesting, I'm not sure whether Sai and I diverge on this, about where Trump has been exercising presidential power, but again, it's one that's, I think, well in keeping with historical practice, and I think is a fair reading of the executive power clause in a way that I favor and make the case for my book, is terminating treaties. So you don't have to get 2/3 of the Senate to terminate a treaty. You don't even need to get half the Senate to terminate a treaty. Presidents have been terminating treaties on their own authority for a long time. Again, some people thought Trump was outrageous for terminating the Iran nuclear deal, the Paris Accords on global warming, 2 arms control agreements with the Russians. But I think that's actually part of the executive power, because the Constitution only talks about how you make a treaty. It doesn't talk about how you terminate it, just like it talks about how you appoint officers. It doesn't talk about how you fire them. And so we read the Constitution as reserving those firing and termination powers in the executive branch. I'm still working on some article I call the reversal power, which is that one of the great presidential powers, which we don't even think of as one, is the president's power to just undo the actions of other presidents and other branches in ways that are easier than it took to make them. I think that's actually an important check that presidents have on past presidents. But you wouldn't know it if you were following the press about Trump. You'd think he creates some great constitutional sin by pulling us out of the global warming accords. But actually, that's what President Obama, when he made them, used his own presidential power, got no approval from Congress, as Sai said, and from the Senate. So I don't see why President Trump couldn't undo it.
I think that that's an excellent segue to the next question we have here, which relates to Daca. The Supreme Court has restricted the power of the Trump administration to change the policies of past administrations, like the questions on the census and Daca. Does this indicate a growing permanence of the power of past presidents?
Well, I think Sai and I probably do disagree about the initial program, but I don't know if we disagree about the Daca case from the summer, the Regents case. I think, of course, I think there is a power in the president to make prosecutorial decisions, which we call discretion, about where to emphasize enforcement. And they can have differences about that. President Obama versus President Bush might have had a difference about how far to pursue drug dealers and or marijuana producers and users. But I don't think that a president under the Take Care Clause can push enforcement down to almost 0 cases. And that's basically what President Obama did, I think, in the Deferred Action for Children program and then the DAPA program. President Obama basically said, I disagree with Congress's policies in the immigration laws. He didn't claim the laws were unconstitutional or defective in some way. He just said, I don't want to remove anywhere from 6 to 8 million aliens as required under the law. Now, he can't remove all of them because there aren't enough resources. But I don't think a president has the right to say it's going to be 0 too, because then he's not taking care that the laws are faithfully executed. Now, as I was just saying, the check on that is that the next president can then come in and say, well, I'm going to change prosecutorial discretion decisions and I'm going to restore enforcement of the immigration laws to where they were before President Obama took office. That's essentially what President Trump did when he came into office in 2017. What I don't think makes any sense at all is for the Supreme Court to then come in and say, even though this program is created under prosecutorial discretion, you have to go through the Administrative Procedure Act to undo it. It's actually harder to undo than it was to make in the first place. That actually runs directly counter to the traditions we usually have about how the executive power works. And if that's true, and I argued this in a piece, well, then President Trump can do all kinds of things, and it'll take a long time for Biden to undo them if he becomes president. President Trump can say, I'm giving everybody a 50% tax cut. I'm going to tell the IRS, you got better things to do than go collect taxes in the middle of a pandemic. Just chase foreign corporations around and get them to pay more. And then if President Biden and the Congress want to undo that 50% effective pay cut, they have to go through the Administrative Procedure Act to do it. So I think the Supreme Court got it completely wrong, and in a way that actually strangely encourages executives to misread or even violate the law because they know it's now harder to stop them.
I agree with John's comment about the Supreme Court and President Trump. John and I disagree about the legality of Daca and DAPA. John has a great article in the Texas Law Review where he criticizes President Obama, and then I wrote a short response on their online forum.
Wait! This is the first time you wrote a response to that. I never heard this before.
Oh, you didn't know that? I've mentioned it several times. Yeah. You should read it.
Yeah, I'm not going to do it. I just wanted to know that you did it, but I'm not going to read it. I mean, come on.
I thought you told them to ask me. Anyway, we'll go to the next question.
Oh, I didn't know that.
So this one might be more directed toward Professor Yu. What are some important differences between the Bush and Trump administrations' respective approaches to executive power? I take it that Professor Prakash thinks that there has been a sort of general unified trend regarding executive power.
So it's interesting. I don't think there's any big difference in their claims about war. I think, President Bush, of course, claimed the same powers as commander in chief that Obama and Trump claimed. Same right to terminate treaties. Bush terminated the ABM treaty, for example, which actually had been ratified by the Senate. So I don't see any big politically, of course, they're completely different. But constitutionally, I don't see big differences. They both made very strong claims to be able to fire executive branch officers. They both, so one thing I would say is not really different, but a lot of people think is different is their approach to the courts and judicial review. So President Trump says terrible things, insulting things about judges, which presidents really shouldn't say. But actually, when it comes to how they handle court decisions, I don't think the Trump administration has really been defiant. So take the Trump travel ban in 2017. Single district judge in Seattle and then another one out here in San Francisco issued nationwide injunctions to block this travel ban from Muslim countries, which I thought was illegal in its first version. But the Trump administration didn't defy that. They could have said, you're a district judge, your remit only extends as far as the territory of your district court. How do you get to issue an injunction for the whole country? But they didn't do that. They steadily appealed all the way to the Supreme Court, and they changed the order 2 more times until it removed the offending parts. So there is this image, I think, out there that Trump is this kind of swashbuckling, defiant, resistor to the courts. But in actual practice, I don't think he has been any really different than the Bush administration, or I think the Obama administration for that matter.
I agree with John.
Let me try to synthesize a couple of questions. A lot of people are interested in sort of what I would describe as sort of one-off killings of American foreign policy targets by drone or by special forces. Alaki, Osama bin Laden. There are differences between these figures. How much do those differences matter when it comes to the extent to which the executive is authorized to go after these people? Is he doing it under the war powers? Is he policing piracy? What exactly is going on when the United States government targets individuals?
So I think let's say there's two different kinds that you've mentioned. One is people connected with Al Qaeda, terrorists, and then people who are fighting on behalf of a nation, like General Soleimani, the Iranian general who was killed at the very beginning of this year in Iraq. So I think they're both legal, but for different reasons. So with Al Qaeda, once Al Qaeda attacks the United States on 9/11, the president is just using force to defend the country in response. I think both Sai and I would agree you don't need a declaration of war in that circumstance. Congress went ahead and authorized it anyway. In the second case, now that's one where I think Sai and I would have to disagree. You could conjure forth, I think, creative readings of the Iraq authorization to use military force, which has not been terminated by Congress yet. And the killing of General Soleimani was on Iraqi territory. I think the Trump administration did claim that it was acting under that statute. But if they weren't, or if suppose the statute doesn't reach that far, then I think Sai would have to say that was unconstitutional. Whereas I think the president is allowed to use force, particularly there where he thinks it is in defense of American interests and American military lives. I think General Soleimani was someone who had planned and ordered the killing of hundreds of Americans and American servicemen and women in Iraq. So I think he's a perfectly legitimate target. The second question about whether they're legitimate targets under the laws of war is different. Now, Congress has not passed a statute trying to impose targeting conditions on the executive. It's not clear to me it would be constitutional if Congress did, because I think that might intrude on president's commander-in-chief authority to carry out the war. Can you imagine in World War II if Congress had said President Roosevelt has to invade Japan first, not Europe, or we order the president to move all the aircraft carriers to the Pacific or to the Atlantic and have none in the Pacific. I think those would be equally unconstitutional, because I think the commander-in-chief power means that the executive controls, that the president controls tactics and strategy in combat.
So these are difficult questions. I think John's got my position right. I think with respect to, Al-Qaeda figures, including al-Awlaki, I think the AUMF covers them, the first AUMF, the 2001 AUMF. And I think that's true whether or not they're in Afghanistan. As John knows, and as you guys know, the AUMF doesn't specify a particular battlefield. It just talks about the people and organizations and nations who helped organize or helped carry out the 9/11 attacks. And I know that al-Awlaki is a US citizen, but we had an entire civil war where we killed our own citizens. And I don't think people thought there was a restriction on it, because of course, when you're fighting a war, you are either trying to capture or kill the enemy. And that's no less true in a civil war. So I don't think the fact that he was in Yemen and not in Afghanistan really matters. John's right about what I think about Soleimani. I think Congress has to decide that we want to wage war against Iran. Having said that, I also agree with John's characterization of Soleimani. He had the blood of hundreds, if not thousands, of American soldiers on his hands. And what's amazing is that the United States didn't do anything openly until that point, right? This had been going on for decades, at least a decade and a half in Iraq, where the Iranians were funding a proxy war against us. And to my knowledge, this is the first open attack on an Iranian asset. And from a perspective of just, of what the US should do, not from a legal perspective, I think it was a very good decision on the president's part. And as far as I can tell, nothing untoward happened from it. But I think, there are civil libertarians who think the al-Awlaki strike is problematic, and the Obama administration put out some long document justifying it on constitutional grounds. But I don't really think any of that was necessary. I don't think you need to go through a long Fifth Amendment analysis or a Fourth Amendment analysis to decide whether you've unlawfully seized al-Awlaki or haven't given him due process. I think the Constitution contemplates that in a rebellion, you can kill people who are fighting against you, even if they are U.S. citizens, and there's not going to be judicial review of any of that.
Okay, we also have several questions sort of centering for Professor Prakash on the question of sort of what strategies could be used to roll back sort of presidential power where it has exceeded the limits defined by the original Constitution, or the Constitution as understood as an original matter. Would it have to be Congress cutting off funding, the courts, the states? Who's in a position to do something about this, and what would they do?
So in the last chapter of the book, I provide a bunch of reforms that Congress could enact if it wanted to rein in the executive. And I think, some of the problems that Congress suffers are self-inflicted. They've gutted their own staff, and they've, through partisan differences, have weakened their own effectiveness vis-a-vis the executive branch. So I discuss a bunch of legislative reforms that Congress could enact that would make advice and consent better and focus them on the real players in the executive branch and not on the bit players. The National Security Advisor is not an advice and consent position, whereas the Office of Information and Regulatory Affairs is. If OIRA is, why not the National Security Advisor? Why not the Chief of Staff? These two positions are far more important than many advice and consent positions today in terms of their influence on what the executive branch does. No one cares about the Assistant Secretary for Procurement, but everybody cares about who the National Security Advisor is. Think of Henry Kissinger, far more important than the Secretary of State during the Nixon administration. And you might say that the National Security Advisor is oftentimes more important than the Secretary of State because they have the president's ear. So there's just a number of things I discuss in the book, and you'll have to go out and buy the book and see all those wonderful reforms. But I think there are things that, of course, I think there are things that Congress can do. The problem isn't, I think part of the problem is a lack of knowledge about what Congress can do. Members of Congress aren't fully aware of their constitutional authorities. But part of the problem is not something that you or I can solve, right? Congress has to decide that it wants to be serious about its institutional role and institutional prerogatives. And if it's not, no book or no set of reforms is going to change it, right? If the Democrats do what Republicans have done, I think, during the Trump administration, which is just, slavishly approve of whatever the president does in service of the party agenda, then there's not going to be any real prospect of pushing back on executive power during the next administration. And I'll say, to my Federalist friends, my book on the expanding presidency will seem more congenial during a Biden administration than will John's, because John's book is more of a defense of the robust presidency we have today. And I'll say this without regard to the presidency, right? John's theory of the presidency doesn't expand or contract depending on who's in the office. So he's consistent, but so am I. It's the politicians in Washington, in Congress, that tend to be rather inconsistent.
Maybe we can provoke a little more disagreement from the two of you with the following question about Professor Nelson's theory of constitutional liquidations, which I assume you're both generally familiar with.
So Caleb and I and Sai all shared an office together at the court.
Right.
And I always felt I needed a translator to explain what Caleb was saying then. And I really need one now because I am not keeping up with Caleb's work on constitutional liquidation. Is that like a fire sale where you get to here, take a constitutional provision, 40% off, 70%? What the hell is a constitutional liquidation? I mean, what is it?
I think it's a fancy way of describing the role of past practice and past, constitutional interpretation in resolving disputes and undeterminate provisions of the Constitution.
It's a reference to Madison's discussion of liquidating the Constitution's meaning in practice, right? That the Constitution has a bunch of phrases whose meaning is in doubt, and then practice will liquidate the meaning. which I think
This is like
implies
from Madison's signing statement about the Bank of the United States.
that's an example of it. I think that's an example.
So I guess, do either of you want to take the position that practice and history have become sort of so strong on a particular point on which the two of you disagree, that it would resolve it in your favor?
So I'm an originalist, actually, like Sai. I think we just differ. I don't think any historical precedent has the effect of sort of almost amending the Constitution, which is what someone, I think Caleb's view is similar to Justice Frankfurter's view in Youngstown. And instead, I think of using history differently. I think that the framers, the way to an originalist should understand what the framers are trying to do with the executive power was not to try to keep it constrained into this narrow list. This is the problem I think Caleb and other people have, is they think there's a narrow list of powers, and then they see presidents do things afterwards that don't fit with that narrow list. So therefore something's either unconstitutional or they have to come up with some fancy theory for constitutional change. This is what Jefferson had to deal with the Louisiana Purchase. He thought that it was unconstitutional, but he had to do it. So later in life, he said, I was exercising the Lockean prerogative, which says I have to do things which are in actually violation of the law in order for the best interests of the country. I think that's the same. That's just a different way of trying to get out of this problem. I think the reason why they've got this wrong is because they think that you can reduce the executive power to a laundry list. And my view is that what the founders thought the executive power was not just certain powers, but the ability primarily there's a certain characteristic of the power to respond decisively and quickly to circumstances, rather than just say, oh, it's just commander in chief and law enforcement. And so wouldn't it make sense to try to write down all the powers? Because you couldn't predict all the things that might come up in the future. But that said, then the history doesn't show like, oh, that's a precedent that just means the president's powers just stay there all the time. Once an emergency or circumstances disappear, then I think the presidential power has to recede because it's not justified anymore.
If I could just quickly respond to the question, I think the theory is something like early practices after the Constitution help us better understand the Constitution. And it's based on the sensible supposition that they would have been better at figuring out what the Constitution meant than we would 200 years removed. And I think at that level, it makes sense. The court has said that early practices matter in constitutional interpretation. Marsh versus Chambers is such a case. I think where, I might disagree with some liquidationists, Will Boat has written an article on this, is the idea that you can liquidate and then reliquidate, right? You could have one set of practices at the founding, change them in the 1820s, change them again in the 1860s, and then establish new practices in the 1900s, or the 20th century, and then that would be the proper meaning. And I think that is just an evolving approach. It's not uncommon to think that practices after the enactment of a text shed light on its true or proper meaning. I think that was the original concept of the deference that agencies get with respect to the statutes they enforced, or at least that's what Aditya Bamzai, my colleague, has argued with respect to Chevron.
Very good. Thank you both so much for your time, for your thoughts. This has been a fascinating event for me, and I'm sure our viewers have enjoyed it very much. There's quite a few of them. Thanks again, and everyone have a good evening.
Hey, Jack, it was great to be with you. John, great to be with you. The folks in the society, if you want to continue the conversation, feel free to give me a call or send me an email. Okay, sorry we couldn't get to all your questions.
Yeah, thanks everybody.